Hi everyone, thanks so much for joining us today. My name is Alicia Lord. I'm with MCAL and we are partners on this project. I'm just here helping to facilitate today. Alicia Aiken is here from the Confidentiality Institute. She will be presenting in just a moment. I'm just going to go over a couple of things in the platform for you. Please use the chat if you have any comments or questions throughout the presentation. If you would rather speak during the Q&A, just raise your hand and we'll unmute you and call on you so that you can ask your question or state your comment. We encourage participation, so whichever method you prefer, just let us know. If you do have any technical issues, if you have issues seeing the slides or audio problems, just let me know in the chat and I can help you troubleshoot that. Thank you so much for joining us. I'm going to turn it over to Lish and you can get started whenever you're ready.
Terrific. Thank you so much, Alicia. Good afternoon. I guess it's afternoon for many of you now. My name is Alicia Aiken and I'm the director of Confidentiality Institute. I know we have an hour and so my plan is to dive right in, but I want to emphasize what Alicia said, which is ask questions as you have them. I may pause and when I answer them, because I might know that the answer is coming, or I might take them right away. But it allows me to make that judgment call while we're talking. And I'm going to be back in 2 weeks. So that also means that if there are questions that come up that don't quite fit into today, but we can answer them in 2 weeks, then I will have seen them and I'll be able to prepare for it. So what I want to focus on today is this question about confidentiality and information sharing in elder abuse MDTs. And oops. Real quickly, in case any of you have not met me or done a training with me before, I am the director of Confidentiality Institute. I've been doing it for 10 years now. And so we bring national expertise on crime victim privacy kind of across the breadth of crime victim experiences, but we were founded originally to address the needs of domestic violence and sexual violence survivors. I'm a lawyer, which means I'm going to talk like a lawyer, but part of what I'm trying to do is help people who aren't lawyers learn how to talk to lawyers and decode some of both the words and the power games that lawyers play. It's my people, it's what we're taught to do, and it's what we bring to the world. And so I like to be a person who can help other folks to navigate that. I spent 15 years representing survivors of violence and families experiencing poverty at Legal Aid in Chicago. And I spent a lot of my time consulting with multidisciplinary groups on confidentiality, but also on collaboration and strategy issues. We want to take a moment to say thank you to OVC. They are the ones providing the funding that makes it possible for me and Confidentiality Institute to be here today. So for this hour, what I want to do is help you as project coordinators, help your teams to identify the questions that you're going to need to get answered locally, to highlight some of the information sharing norms for professionals that are commonly on MDTs. And this is really a highlight. It's going to be very important to have these conversations locally, but this will give you a starting point. And to better understand how MDT team information norms impact the group and how the group thinks about working together. So that's really, whenever we're collaborating, right, there's this idea that it's a puzzle and we all are bringing a different piece to it and we're trying to figure out how do we solve a problem by bringing what each of us has that is different to the table. And the questions that I get about all kinds of collaborations, really, whether it's a family justice center or an MDT or a SART or a child abuse MDT or a fatality review team, the questions are sort of the same, which people will call me and say, given my profession, my role, can I share this? Will you just tell me what I can't share? And Or will you tell me why those people over there won't share stuff with me? I have come to understand that this question is the tip of the iceberg in terms of folks not having a lot of questions that they may not have even realized or formulated about their group, what the group is doing, why the group exists, and why they are on it. Because once you know the answers to those questions, you can then figure out under whatever your local law is for the profession at issue, what you can or can't do. But lots of folks walk in making assumptions, and lots of times different folks make different assumptions. And so my goal today is to give you a strategy for answering the questions locally about who your group is, so that each professional can then do their ethical responsibility to answer the question about what they're allowed to share or not to share with the group and how they might go about thinking about it. Because whenever people call me, I'm much more likely to say to them, it depends, when they ask me what they can or can't do, than to say right or wrong, which is the question that everybody hates. You know, it's the cliche that a lawyer will always say, well, it depends. What I'm going to do today is to tell you what it depends on, so that you can get the answers to those questions. And then if you need help trying to figure out which is the right local law to look at, then I can probably give you better technical assistance. And this people don't always like this answer when they say, what can I share? And I say, I want you to take a step way back and start over asking different questions about your group before you ever get to this question of what can I share? So your team needs to reach consensus about these 5 things. And then I'm going to talk about these 5 things in more detail. But I think this is the starting point to thinking about information sharing, which is, what is the purpose of the team? And I can't emphasize enough how much you shouldn't make assumptions about this one. And we'll talk about it in more detail in a second. Who are the participants on the team? Both who are they, and what is their role? Why are they there? What's the law for the team? The team, sometimes there's special law that applies to the kind of team you are. And what is the law for each team member? And then what are the norms and expectations in your group around information sharing? I'm going to take a pause and open the chat box. Oh, you guys are just introducing themselves. Wait, is there seriously someone on the call named Nancy Aiken from Baltimore? Because hi, we're not related. Nancy Aiken, previously of Annapolis, is my great aunt.
Well, I am from Annapolis, but I don't think I'm your great aunt.
No, she lives in New Mexico now.
But yeah.
Hi, that was a super confusing moment for me. Okay. All right, so let's break each one of these questions down about what am I really saying we want to get at? What is the purpose of your team? I can't tell you how often I go into with groups, and they give me different answers to that question, right? And so we have just launched a poll, not launched a poll. Okay, I have the ability to launch a poll when I'm ready. That's a good thing. So we're gonna hold that for just a moment. Sorry for giving you like that behind the curtain. I'm incapable of maintaining a wizard-like veneer. Okay, so some of the common purposes, and this is based on research I did about elder abuse MDTs and how they sort of construct their work. Some purposes may be to review individual complex cases, to improve the whole system, to facilitate referrals and get individual people's needs met, or to increase prosecution. So I routinely go into groups and I will hear different people on the group announce what the purpose of the group is and see other people in the group say, that's not the purpose of our group. So it seems like such a simple question, but it actually is one that bears some important discussion. So let's go ahead and launch that poll now. So do me a favor, the elder abuse MDT team that you are on or building, what is the purpose of your team? And you can check as many of these as are right for you. I just want to give it a moment for everybody to have a chance. Terrific. Okay, so I'm sharing the results with you. So the great news is nobody said, I don't feel certain, which is terrific. All of you said that the purpose is to review individual complex cases. And 8 of you said systems improvement and facilitating referrals. And then half of you said increasing prosecution. So you're already honestly ahead of the game. I think the next step is making sure that everyone else on your team agrees with you. And when I say agrees with you, it doesn't necessarily mean you go in and say to them, this is the deal, you all have to get on board. You say, I want to check in. This is what I think we're doing. Do you agree? And if we don't have agreement on what we're doing, then we need to have more conversations. Because what can get difficult is sometimes these different goals are in conflict with each other. Right? So prosecution is a really complicated issue. That there are a lot of ways in which prosecution is believed to increase accountability. Maybe it's a deterrent, but it can also do a lot of harm, especially in communities that have been marginalized and over-targeted by prosecution. So if your system concludes that in order to improve the overall system, in order to improve elders' willingness to come forward, to seek help, and to increase their well-being, prosecution is not actually the thing that your community thinks is the most helpful. Your group has to think about how do you navigate that if you have identified increasing prosecution as one of your core goals. The other thing that can be an issue with prosecution is that in prosecution, well, I'm going to talk about this in a second. I just realized I have a slide, so I'm going to pause. The other thing that's good to be aware of, and I don't know if this is an issue for any of you, but a lot of times a group gets formed by well-meaning legislators, whether it's local or statewide or even federal. They will announce and create a group and then announce who's on the group. And you may be required to follow whatever purpose was defined there. Or maybe they created the group and put people on it, but didn't define the purpose. And then some people, it doesn't make sense to have them there because it doesn't fit the purpose. So sometimes there are complexities that you need to look at and navigate and think about as a group. Because if you don't work those things out, you're going to be in a great big tug of war, right? And the meetings are going to feel painful and difficult. And that's where I start seeing people disagreeing over information sharing and having conflict around that. But as I said, I generally find out that the real conflict is around whether there's a consensus about what you're doing. Because if there's a consensus, then you should be able to resolve information sharing questions pretty easily. So I think there are a lot of consequences of choosing increasing prosecution as a primary purpose. I'm not saying that anyone should not do it or do it, but I'm saying it's really important to consider these things. So first off, if you are increasing prosecution, that means prosecutors and law enforcement are in the room. And that means what is shared with them becomes essentially part of the investigation and can expose it to further disclosure that may not be what you intended or wanted or what elders are okay with. So being very aware that there is a consequence to choosing prosecutors in the room as part of your goal that you have to stay attuned to. And then the second thing is that there are some ways in which local healthcare professionals may be able to share with your MDT if there is an argument that it is about promoting healthcare. That they can then make an argument under HIPAA that it's about promoting healthcare or public health. Prosecution is not healthcare, prosecution is not public health. So making a decision like that may narrow the ability of medical professionals to share in the group. I say may because, again, there's going to be some local questions to work out, but that is a potential consequence. Okay. Any questions so far? I want to make sure that I'm not rolling forward without the group. I'm going to keep going, but I'm keeping an eye on the chat. So if somebody has more questions, I'm happy to take them. Okay, the second question to ask is, who are the participants on the team? Who should be here on the team generally? And then who should be exposed to which information, or who should be in which meetings? So again, remember I said, like, all of you said that your goal is to review complex individual cases, but half of you said increasing prosecution is the goal. So there may be times that your team is going to review individual complex cases, but law enforcement shouldn't be in the room because they don't have anything to contribute, and they bring in exposure to disclosure of information that isn't actually helpful or necessary in that moment. And that's not about kicking them off the team. That's about saying the purpose that we are doing right now is addressing a healthcare access to resources issue that is unrelated to law enforcement. And so we're going to ask to have a separate meeting that you're not part of. I think it's incredibly important for groups to develop this kind of relationship where they can say sometimes a smaller portion of the group is the right number, rather than assuming that every meeting will include the whole group. The other thing that's really important to pay attention to is potential conflicts. So there may be circumstances, especially in smaller communities, although really this can happen in any community, that someone who would normally participate actually has a personal conflict that would make them not the appropriate person to be here. And so thinking about how do you create a process for people to name that and say, I need to step out on this one, right? Judges call it recusing themselves. So if there's a case in front of the US Supreme Court and one of the judges actually is new on the bench and decided the case in a lower court, they recuse themselves because they have a personal conflict that makes them not appropriate to hear this one case. Doesn't make them any less of a judge. It just means in this moment, the right thing to do here is to not participate. So really having kind of a robust, appropriate process for that is, I think, very important. And I see very few teams that have thought that through. The second question when you're thinking about who's on the team is why should they be here, right? What is their role in the room? This is another thing that I don't see teams discussing. There is often an assumption that social workers, healthcare workers, victim services providers are in the room solely to deliver information to lawyers and police officers in the room. It is possible that that is somebody's role in the room, but it's possible it's not. And if there's an assumption made that the reason they're in the room is to answer questions about the crime victim, and then they say, hey, there's a law that says I can't answer questions about the crime victim, then the rest of the group can tend to say, well, then why are you here? So you want to be able to know the answer to that question. People are bringing expertise. Do you have them in the room because they have expertise, even if they have never heard of the individual person whose case is being considered? Or are they there to bring information about individuals? Are they there to carry information to individuals? And this is an important question, which is, if there are people in the room who are directly engaging with the elder, what are they empowered in terms of information to deliver to the individual, to take back, so that the elder or the guardian of the elder, whoever the appropriate people, understand what's happening in terms of the review, the network, the access to services. Sometimes people are there to learn. Sometimes people are in the room because they're researchers. Sometimes people are there because their job is to advocate for systemic improvement in the community. But knowing the answer to that question, and it could be more than one thing for people, but both knowing the answer to that question and communicating the answer to that question to everyone else in the room is an important step. So this comes up all the time with victim service providers. And I really encourage you to think, do you have victim service providers on your MDT? And if you do, why are they there? And does the whole team know why they're there? What has this been discussed? And are you communicating with everyone on the team why they're there? Because we all know that I'm assuming all of your teams either have or will experience turnover, where the person who comes from an office could change from month to month, or they could move on to a new position and then somebody replaces them. And new people whether it's a constant rotation or it's a job change, new people need to have it communicated to them. What are the, again, the roles and the expectations of the team? And we can talk about tools you can use for communicating how your team works, what it's about, and what the culture is. But we don't want anyone making assumptions. We want everybody to be informed. So the next question to pay attention to is, what is the law for your team? So what do I mean by that? If your team was created by a statute, which it may or may not have been, but if it is, does that statute create rules? Rules about confidentiality that you're required to keep in the team, rules about how your team responds to subpoenas, rules about how and when your team appropriately makes disclosures. I am not making any assumption that there should be a statute. I'm just telling you sometimes there is. You know, one of the things about my experience is that I do technical assistance in all the states and territories and many indigenous nations. And, you know, people are often saying to me, well, we do it this way. And I'll say, okay, what's the reason why you do it this way? And they'll say, well, there's a law. And I'll say, can I look at the law? And then often they say, oh, maybe there's not a law. I can't find it. I don't know where it is. Or they'll say, oh, it's in a contract, or it's in our funding agreement. And then we have to have a discussion about how that's actually different from a law. It might be a rule that you have to follow, but it's not the same thing as saying it's in the law. And then I'll say, well, let's look at it together. And when we look at it, it often doesn't say what they thought it said. So getting back to that question of why are people on a team? A lot of times I'll see a funding agreement or a statute that says, for instance, victim service providers will be on your team. And then the group has made an assumption that being on the team means you share everything you know, but it doesn't actually say that. And there are other laws in place that might prevent that victim services provider, in fact, almost certainly does prevent that victim service provider from sharing everything they know. So you really do have to take the time. And if you've got, it is utterly appropriate if there are any lawyers on your team or paralegals or other legal workers to ask them to do this research. Like, can you help us, you know, make sure we all know? But it is a question of looking at both statutes and possibly looking at regulations in your state, looking at any contracts that have been signed or any funding agreements to get a sense of it. Again, if this is something that any of the teams are sort of struggling to sort out, or even if you've got a lawyer who can help, but the lawyer's like, I'm not sure where to start. I'm only licensed in one state right now, but I actually have experience researching in pretty much every state because it's the nature of the work I do that I have to go digging around. So I can often help people figure out how to get started finding stuff. So here's an example of something that is often statutorily handled, which is fatality review teams. And I know that MDTs are not necessarily the same as fatality review teams, although it's possible you might develop an elder violence fatality review team at some point. Many of the state statutes for fatality review have a rule that says everyone on the team must share everything they know with the team. And that actually becomes an exception to any other confidentiality or privilege rules. But it also says that all the discussions that the team has are confidential and that no one on the team is allowed to respond to a subpoena or share any information. So what it does is it says you're required to share in this space, but what's shared in this space is private and is not at risk of exposure. Now, the downside to that potentially for an active MDT working with living survivors who are trying to connect to resources is that could in fact have the consequence of limiting what you're allowed to tell that elder about what's happening in the team. So I always want folks thinking about what is the flow of information into the team, how is information that's in the team circle managed, and what's the flow of information out of the team, and thinking about what the expectations are at each stage, into the team, while it's in the team, out of the team. Let's talk for a minute about MOUs, Memorandum of Understanding, or MOAs. They are not laws. MOUs are not laws. They are agreements, they're contracts. really. It's a very interesting thing to me that in the nonprofit world, we tend to use MOUs a lot when really we're just signing contracts. They are agreements about how folks will work with each other. They are understandings, but they are not statutes or laws. And so MOUs don't have the power to change existing law. If there is an existing privilege or confidentiality law that says a professional cannot share, there is nothing you can put in an MOU that will change that. So a lot of times people will say to me, well, I share freely in a group, even though I'm a privileged professional, because we have an MOU that says what happens in the group stays in the group. But there is nothing about an MOU that can change existing law. They are contracts between private parties, individuals, or groups. If there is a criminal or a abuse reporting law that requires sharing, no MOU promise will change that. So I do see an over-reliance on MOUs to try to change existing law, and they cannot appropriately or properly do it. So they're not a good strategy for that. They are a fantastic strategy for communicating group norms and expectations, and for saying, we have all put in the MOU why we're here, what the goal of our group is, what each of us can or cannot share in this team. And we've all signed off on it. And then when new people come, we give them the MOU and say, one of the things you need to do before the next meeting is read this, so you understand who we are. So they're fantastic for creating culture, but they cannot change law. So this is an example I see a lot that honestly concerns me, where I will see teams that have MOUs, and the MOUs say everything that happens in this group is confidential and it cannot be shared outside of the group. And it is signed by prosecutors and police officers. And prosecutors and police officers must disclose exculpatory evidence. And all exculpatory means, I like it because it's fun to say, but all it means is that it tends to show that the defendant is not guilty, or discredits a prosecution witness, or reduces the seriousness of the offense. So all three of those are things that might come up if there is a pending prosecution and things come up in your MDT and a prosecutor or law enforcement officer is in that room, they have to share with the defendant and the defense attorney anything that might show that someone's not guilty, discredits a witness, or reduces the seriousness of the offense. So that should make your prosecutors very cautious about what they get exposed to. But I've seen a pretty wide variety of behaviors around the country. And it does not matter if they sign that MOU. And culture is that thing, right, that is so present in our lives that we can't see it. It is the air we breathe. And so one of the things about an MDT is you are bringing different cultures together. And sometimes the hardest part is for different cultures to remember to name the things that are in the air you breathe. I mean, I literally couldn't, I'm a lawyer, which means that I wasn't great at science, otherwise I'd be a scientist. So I can't remember what's in the air I breathe. If you asked me to list the elements, I'd be like oxygen, carbon dioxide, I'm out. People have to take the time to name the cultural air that they breathe in their profession and what they're bringing to your team. And what's interesting, I think, is that it turns into a power hierarchy question, that folks who have to defend their culture, often victim service providers have to spend a lot of time defending their confidentiality culture. So they may be more likely to say out loud, I can't share, or I have to mandatory report, because they spend a lot of time being required to defend it because they are unfairly lower on the power hierarchy among professions, right? Unfairly lower on the power hierarchy of profession. Folks at the top of the power hierarchy of professions, and you know who those are in your community, don't have to say what their rules are. And so they don't have a whole lot of practice and they may not think of it. So part of being part of this group is naming your sharing roles. And this is an example that I often see prosecutors say, yeah, I signed the MOU, everything's confidential. And I have to say to them, what about exculpatory? And they go, oh, well, I mean, obviously exculpatory is shared. And I'm like, well, obvious to you, obvious to me, because I have a law degree and I used to do criminal defense, but not obvious to your partners on your collaboration. So, no assumptions, nothing's obvious, everything needs to be articulated. So that brings us to the fourth question, which is closer to, the question that people are actually asking me, which is what can I do and can't I do? What is the law for each team member? So that's an individual responsibility for people to find out, right? It is your job to figure out what your professional, ethical, legal responsibilities are, and then educate the team. But it's going to be a lot easier to do if you have the answers to the first three questions that I posed. And Confidentiality Institute can absolutely provide technical assistance when folks are like, okay, I know the answer to the first three questions and I know who I am, but I'm not sure how these puzzle pieces fit together, because collaborations and MDTs may not fit neatly into existing rules. There's the joy of being an innovator is that the law is slow to catch up, and so may not yet have considered your work. So a really a common example of that I see is what are the rules under HIPAA with elder abuse MDTs? And it can be tricky. There's not a direct answer. There's in a lot of ways a direct answer around child abuse MDTs or child death fatality review teams, but not necessarily elder MDTs. So it takes sometimes some work to go through the different pieces of the rule to figure out how they apply. So that might be a place where folks need help either from their licensing board or from a lawyer or from a technical assistance provider. And that really is reasonable to ask for that kind of help. But I like to warn folks, it might not be immediately obvious and clear, or the rule might be really clear and folks might not agree with it. Like they might be like, but that's not good policy. And they may be right that it's not necessarily good policy, but it's the rule they have. And we don't get to throw those rules out because they're not good policy. If we're trying to improve systems, then one of the things the groups can do is think about what would improve our systems. What are the things that exist now that didn't consider the kind of collaboration we're trying to do? And so they impede collaboration. And we wish we lived in a world that didn't impede collaboration. Well, awesome news. We live in sort of on paper, democratic power sharing societies where we can adjust our rules to fit what we're trying to do. And so sometimes you got to name those barriers so that you can try to fix them systemically. But it's important for folks when they're trying to figure out what their rules are to pay attention both to what are the rules? Remember I said there's three stages of information. There's into the group, how do we manage it when it's in the group, and then what goes out of the group. People need to pay attention to both questions. What am I allowed to tell this group? And then what are the rules on what is allowed to leave this group? Because they are two different questions and they are important, both of them. And again, this is for a good cause. This is an innovation that we think will protect older adults. Important policy initiatives do not change existing law. Right? And this is something I think people struggle with a lot. Do I have the power to decide whether to share with this group? Do I, the professional who possesses information, have the power myself to make the judgment call whether to share with this group? That is a very different thing from the question of, that's a very different thing. It is a very important first step. And I'm going to give a couple of examples of two professions that actually have, that we often will say, oh, I'm confidential, I'm privileged, but they actually have a different approach to this discretion question. But if your law, your rules do give you the power to decide whether to share with this group, then the second question you have to ask is this in fact helpful to share with this group? Does it do more good than potential harm? What do I need to think about in making that judgment call? And this is where having a really clear, accurate memorandum of understanding helps people answer the question, because then they know, they're like, okay, well, here's what's likely to happen. Here's what are the potential downsides, and here are the upsides. So this is going to help me make my discretionary judgment call. It'll help me decide whether to sign this MOU, join this group. But if you don't have the power to make that call, then then you don't get to say, I can share this because I think it's a good idea, if the law has said, not your decision. And I'll tell you what I'm talking about with this. So attorney confidentiality is a funny thing, because the cultural air that lawyers breathe, and that frankly the rest of the United States breathes, because lawyers are so much in our entertainment culture and our sort of, I think we are an over-lawyered country, to be honest with you. But attorney ethics prohibit sharing client information. It's confidential. We feel like we've all heard clients say that, or lawyers say, I can't share that with you. It's confidential, it's privileged, except if the client gives you instructions to share it. So that's reasonable and it makes sense. So the elder is allowed to say to their legal aid lawyer, I want you to tell the people at the MDT what's happening. Or the guardian who has retained the lawyer is allowed to say, I want you to tell the MDT what's happening. Or if the attorney believes that the client impliedly authorized sharing, which really means I believe as a lawyer that my client would want me to share this because it would help the case. So you may hear lawyers sharing information without stopping and checking with their clients or having a written consent form, because they are making that judgment call. Is this impliedly authorized to help the case? How does a lawyer know that? Well, having a really great answer to the first 3 questions that we talked about helps lawyers figure that out. I will say that this is a very tricky proposition for survivor-centered lawyering, because survivor-centered lawyering assumes that clients are the experts in their own lives, and that they are trying to achieve a broad set of goals, and a legal case is just a little piece of it. And so sometimes lawyers make a judgment call that something is good for the case without knowing that it's actually harmful to other parts of the client's lives. So survivor-centered lawyering requires a really sophisticated approach to communicating with your client, and sometimes not exercising authority that the ethics might give you. But to the extent that we hear lawyers sharing, confidential privileged lawyers sharing, and we don't see them submitting signed consent forms or checking in, it's because of this. It's because they have permission. And I'm going to tell you, I had been practicing for a decade before I ever noticed this part of the rule. I mean, if you had asked me, I would have recited the rule, but I didn't think about what it meant. And I didn't think about how it matched up to the way I behaved all the time and how I had been taught to behave. Because I had been taught that sometimes it's my discretion to decide, I think my client would want this. And I exercised it actively as part of being an advocate and a lawyer for my clients. Now, victim services confidentiality is very different. Federally funded programs are prohibited from disclosing identifying information. They are only allowed to share it if they have written instructions from the violence survivor, or if that violence survivor has a legal guardian from that legal guardian. If the guardian is not the abusive person, and if people have questions about that, we can have a whole different TA conversation about that. But you have to have written instructions, or a statute or a court order that requires it. That's it. There is no third clause that says a victim services provider can decide that the survivor would want it shared, or that the survivor can decide that this is a good policy initiative. Not allowed, not there. But in our world, we use the same word for lawyers and victim service providers. We say they're both confidential, but it actually, there's a different twist to it that matters, and it matters in terms of how MDTs engage with each other. They have no power to decide, I think this is the right thing to do. I don't have to check in with my survivor. I didn't mean to say I hate that possessive language. I don't need to check in with the survivor that I'm working with. They always have to check in. So this is an important difference that I'm committed to having people process. And I'll tell you, I've looked at the privilege and confidentiality statute in every state and territory. We're still working on researching those in Indigenous nations, but there is not a single statute in a US state or territory that says that advocates have permission to decide for themselves what a survivor would want shared. So this is really the standard for the profession. questions so far? You guys have been very attentive and quiet. I want to pause for a minute before we talk about number 5. I've thrown a lot at you. We'll make sure you have this as a handout if you don't already. So you have these things to go back to, not expecting you to memorize it. Questions? You can chat them in. Oh, good question. Yay. Okay. What happens if an elder is on social media without their knowledge? Bonita, can we unmute Bonita and maybe talk a little bit more about that?
Okay, so I live here on an Indian reservation, and I heard you mention a couple of times Indigenous people.
Mhm.
So we're really small communities, but and everybody knows everybody.
Yeah.
And so I just came across a situation the other day where there was an elder who chooses to stay home a lot. They stay home a lot. They manage their own little environment, right?
Mhm.
And so anyway, this lady was one of this elder's relatives was putting his situation on where he was giving his money, he was giving his assets, letting them use his vehicles and all of this, but they put on there that he's alone on medication. And
Oh,
so when I read that, I thought to myself, wow, they don't understand that they're exposing them to the whole world when it's on
right.
social platform. So
Yeah.
yeah, so that was a concern to me. And so
Mhm.
it was I don't go on these I don't go on the newsletter sites or anything like that
Yeah.
for the community, but someone had forwarded it to me. And so that was my first alert, was like, now the entire, not just the
Yeah.
people who go to him.
Yeah. So, okay, so if I'm understanding correctly, it's not a situation where it's not identity theft. It's not that someone is pretending to be the elder and posting a profile. It's that other people are saying, hey, this person helps me, lets me use their stuff, lives alone, like exposing their name and details about them
Right.
on the other person's profile.
Yeah.
Yeah, the
Well,
21st century. Mhm.
my thing was, is it could actually be a potential opening for identity theft, because they were saying he was a war hero from such and such an era, and so
Yeah,
all of these different things that
yeah.
can help someone, create a profile or create a new identity.
Well, so I'm going to give you guys a couple of resources for thinking about social media and violence survivors. So I partner very closely with the National Network to End Domestic Violence. And in fact, I think you guys had a presentation from Rachel Gibson from Safety Net. So Rachel Gibson is fantastic. She's moved on to another position at a new organization, but you can always email questions that are related to technology and violence survivors and confidentiality to SafetyNet at nnedv.org. And they have a really robust blog that has a lot of technical assistance information, answers to questions, and that's at techsafety.org. And so I've put the email address and the web address in the chat. Remember I said that law is slow, and so the law just has not caught up with what is happening on social media, what's possible. What I love about the Safety Net team is that they have close relationships with a lot of the social media companies, and so they kind of know who to get to on the inside. They also advocate for better policy. And so it's good for them to know both what's happening, but also a lot of times they can be helpful. Off the top of my head, from a law perspective, if an individual is posting information about another individual and the person who's posting didn't steal the information, I don't know if there's a law that would prevent that, but the emphasis is on I don't know. And honestly, the folks who are the absolute best at this is Safety Net. And so if anyone has concerns about what's being put out there on social media, whether it's identity theft or oversharing, I suggest reaching out to Safety Net to consult with them about it. Okay. So let's just sort of walk through this group norms for information exchange question, which is another question that you're going to need to answer as part of thinking about who can share what when. What do people expect? What is the process for how people share, how they take turns sharing, and how do we educate everybody? So I have another poll. Alicia, did the other poll make it in? Yes, it did. Thank you so much. So I just want to ask you all a question, which you might not be the greatest sample set because you're so engaged in building your teams and this process, but I think everybody can see. In the last year, how much time have you spent learning about other professions' ethics or information rules? We've got 11 attendees, so I'm just gonna, about half of you have responded. I'm not gonna follow up with you, and it's anonymous, so just whatever your first blush answer is. Okay, just 2 more of you. Give me your best guess. Five more seconds. Okay. So this is actually pretty great. 3 of you more than 2 hours, 5 of you an hour or 2, 1 of you less than an hour. Nobody said, not sure if I've spent any. This puts you at the pretty high end of professionals in terms of thinking about other professions and how they think about information. I mean, the honest answer for me when I first started, before I started doing Confidentiality Institute, is probably pretty close to 0, because I just didn't think I needed to know, right? Unless it came up in one of my cases. It wasn't my problem. But it was actually collaborating. I was collaborating with social workers. I was collaborating with advocates. Sometimes I was collaborating with police officers. And I had not spent any time, and no one had asked me to spend time really understanding their position and where they come from. So if you're going to do great collaboration in an MDT, we have to spend the time. We have to make the time in our groups to do it. And that can be hard sometimes when, we know we're dealing with incredibly vulnerable people who are in need now. And if part of our mission is to review individual complex cases, there is this desire to dive in and start fixing, right? And so sometimes people get impatient because talking about each other's information norms doesn't feel like fixing. And so some of the professions may get itchy and agitated about it. And so we want to really support that this is part of being part of the MDT, and part of doing it well is taking time to learn each other's roles and each other's rules. And these are not meetings that we can I'm going to skip that because we're not talking about any cases. It is part of developing respect that other people come into a room with an ethical position, and everybody comes from an ethical position and they are a little bit different, right? So if you think about, as a lawyer, I have never been a mandatory reporter. And in fact, I think I would refuse to practice in a state that makes lawyers mandatory reporters, because I believe in the ethical position of clients having a safe space to share information so they can get advice and assistance in figuring out what to do next and how to resolve it. There are sometimes downsides to that ethical position. I know that, but I have processed those, and I believe in the upsides enough that I can live with the downsides, and I move forward from that place. Right? I believe every U.S. jurisdiction, social workers are mandatory reporters of child abuse, and I think every or close to every, they are at least permissive reporters of elder abuse. So why? Because if somebody's in harm's way, there is a system that can investigate and take action. And there has been a decision made that it is worth it to engage that system every time rather than run the risk that somebody is going to be harmed. Now we can, folks can have debates about that, but that is on sort of an ethical position on how social workers live out an exception to confidentiality, where they believe that it is good for people to be able to share what's happening so they can make sense of it and try to get help. Those are both ethical positions, even though they're different from each other. Disclosing information to criminal defendants is an ethical position, that it is that we have a criminal justice system where the state has the awesome power to take your body. In many places, the state has the power to end your life. So when they are trying to exercise that kind of power, we have to have fairness and information sharing so that defendants know what the prosecutors know that might help them. That is an ethical position, even though if you're a victim services provider and you find out that a prosecutor shared private information about a victim with the criminal defendant, that can feel very bad, right? That can feel very bad because it rubs up against your ethical position that victims always choose who knows what. So we can manage those differences, but we have to be aware of them in order to manage them. I have seen examples where, again, with victim service providers are so grounded in their confidentiality that they get angry with any other profession that shares information. I have seen prosecutors who are so grounded in the fairness of sharing with criminal defendants that they assume every single profession out there must also do it, even though that's not the law. And so taking this time to ground in each other's, at least an understanding of and respect for each other's positions is how you can collaborate. I love this quote from the Sexual Assault Response Team Manual that's put out in the state of California that says departments that are participating on a CERT can have different objectives, but a shared vision, right? You can have a vision of eradicating elder abuse in your community, but you may be taking different paths to get there. And not everybody has to agree to be on the same path all the time. The big question that I also want to ask folks about information, this has to do with how does information leave the team? And I've already brought this up before, but having a really clear sense, is there a way for team members to bring information to the team at the request of the elder, guardian, or caregiver? What is the proper and appropriate way for that happen? Because especially for victim service providers and lawyers, then you can have a real conversation with your client, and also for social workers and healthcare providers, you can have a real conversation with the person and say, I meet with this group. This is what this group does. This is how I think this group could be helpful to you. What do you want this group to know? What do you think is important to be carried to this group, right? So that we are still centering the person who is having the experience. I actually talk about it a lot and I am an English major, so I talk about it in the way that you would diagram sentences. Are we making the elder who's experiencing violence the subject of the sentence that is the MDT, or are we making them the object of the sentence? And I think part of eradicating violence in our communities is making the people who experience it the subject. Even when we're having interdisciplinary team meetings that person might not be present at, they can still be the subject of the sentence rather than the object that all of us are looking at and trying to fix. The second question then is, if information is shared in the team, what are the rules for sharing information back out of the team to the elder guardian or caregiver, whoever is the appropriate person? Does the team have an accepted process for that? And maybe it's, if you got shared information by another professional in the team, the rule is you don't share it outside the team unless you and that professional have a conversation first, right? You say, I think it would be really helpful for them to know that. Can I have your permission to tell them that? Or can I set up a meeting where you tell them that? And again, that's making the elder the subject of the sentence rather than the object of the sentence, that they might be the one who has the direct conversation. So it is, of course, possible for violence survivors to give instructions to say, I want information shared with this team, but that is not, under no circumstances, is that me saying that you should be getting universal releases from elders or their guardians to share with the entire MDT all the time. It is too big a mix to say, hey, there's a group of people and some of them are law enforcement and some of them are advocates and some are legal services and some are medical and some are social work and some are protective agencies and some run assisted living facilities. And you can already hear how long that list is. You all are very different from each other. And so the consequences of sharing with those different folks are different. And it is too much to ask somebody to decide in advance, yes, I want you to share with all those different kinds of people. It's like the cosmic cereal aisle, right? I want you to decide now that you're interested in having these 35 kinds of cereal over the next year. It's too much choice, and literally people's brains shut down. And that's basic psychological research about what happens when you have to make too many choices. And this is a kind of too many choices. It's also an implied pressure to consent in exchange for services. I do think it's appropriate to say to somebody, that thing you just told me, that thing you and I just talked about, I feel like it would be really useful for the MDT to know that. The MDT, here's who's in it. Here's what I think might be the downsides of sharing that one piece of information. But here's what I think the upsides are. I'm curious what you think the upsides and downsides are. And then the person might say, yes, I want you to share this one piece of information with that team. And I want to sign a consent form that gives you permission to do it. But that is the difference between the subject. A universal release is of saying, can I have permission to treat you as an object of this team for as long as the team is considering your case? And that is not the way that I think we want to be living out this process. So essentially what I'm saying is, like, always part of being in a collaboration is always asking questions, adopting a student learner approach, wanting to understand, being prepared to teach other people where you come from, and being honest about the potential risk and benefits, and thinking about what are possible solutions that don't require anybody to compromise their ethics. I have to say the most useful phrase that I use in negotiation, and this is a kind of negotiation, is what if. And really what I say is, I'm going to throw something out here right now and I have no idea if it would work. And as a lawyer, I would always say, I have no idea if my client would even agree to it, but I just want to imagine for a moment, what if blah, 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 right? It's a really safe way to be able to have a conversation where you can engage imagination and vision without anybody feeling like they're committing to anything. If you are interested in more information on rules, there's that tech safety resource that I gave you. Besides the technology stuff, we have an entire confidentiality toolkit, which Confidentiality Institute has been deeply involved in writing. But there's also information on the HIPAA privacy rule and information on drug and alcohol records confidentiality, which if you have anyone from that field on your team, that's a very strict confidentiality rule as well. And you can always reach out and ask technical assistance questions to me, Alicia, at confidentialityinstitute.org. We partner with NNEDV to provide confidentiality technical assistance to, it's funded by the Office of Violence Against Women, but it's really for anyone who could be eligible. And I just got a question, when will we get a copy of this PowerPoint and webinar? And Alicia, this is a perfect opportunity for me to turn it over to you because I'm right up against time and you can let them know.
All right, thank you so much, Lish. So you'll be getting a copy of the recording and the materials this afternoon. You'll also be getting a link to fill out an evaluation for this webinar. So please fill that out. Let us know what you thought, what you liked, what you didn't like, and any notes for next session as well. Thank you all for joining us, and I hope you have a great rest of your day.
Terrific. And if anyone has questions you'd like to see answered 2 weeks from now, please send me an email. And I'm just going to show you one more time. There's my email address. Thank you, everyone, for spending lunch-ish time with me, depending on where you are.
Thanks so much, everyone. Have a great day.